Good morning, ladies and gentlemen. Thank you very much for, as always, coming in to support your company. The time is 12 o'clock, midday. And can we start by standing for the national anthem, please?
We hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peace or battle honored, and this we count as gain. To hang on to our children a banner without stain. Oh, grant this our one request. Help us to build a nation where no man is oppressed. And so with peace and plenty, Nigeria may be blessed.
Thank you very much. It's a good vocal exercise for the morning, and an opportunity to see who still remembers the national anthem. Distinguished ladies and gentlemen, first task this morning is to ask the company secretary if we have a quorum.
Mr. Chairman, we can confirm that there's a quorum for this meeting to proceed. You may now proceed.
Thank you very much, Mr. Eleyele Ibadan, Company Secretary of Fan Milk. Distinguished ladies and gentlemen, it's a great pleasure that I welcome you to the court-ordered meeting of our company, Fan Milk Plc. The Company Secretary has advised that in accordance with Article 64 of the company's Articles of Association, a quorum has been formed. This meeting has therefore been duly convened and properly constituted. Accordingly, I declare the meeting open. Before we start the business of today's meeting, I would like to formally introduce the board of directors of your company. I am Olayinka Akinkugbe, a director of the company and currently the chairman. Pursuant to the court order convening this meeting, I have been appointed to act as the chairman of the meeting. I would also like to introduce the following: Mr. Kayode Akim Adebiyi, the managing director of the company. Dr. Babatunde Ademola Moyosore Ajibade SAN, the director of the company. I'm also pleased to introduce Mr. Olakunle Oludotun Olusanya, our company secretary. We have received apologies today from Mr. Hervé Orama Barrière, the director of the company, who is unavoidably absent. I would also now like to introduce the various professionals who are advising us and are assisting our company in taking the various steps necessary to implement the scheme of arrangement. First of all, Stanbic IBTC Capital Limited are the financial advisors, Banwo and Igodalo, the legal advisors, SIO Partners, the fairness opinion advisor, Forvis Mazars, the scrutineers, Stanbic IBTC Stockbrokers Limited, the stockbrokers, and Greenwich Registrar and Data Solutions Limited, the registrar. I'd also like to introduce the representatives of the CAC, SEC, and the NESD who are in attendance at the meeting. The representative of the CAC, SEC, yeah, sorry. And the name? Sorry? Obinna Ebuniwe. Thank you very much. And the representative of NESD is also here. I can spot Chilecherem Chanti Anyoke. I hope I did a decent job with the name. Thank you. For this meeting, we have received proxy forms from some shareholders, and please note that the voting on the resolutions to be moved at this meeting will be by poll, which means that every shareholder present in person or by proxy shall be entitled to one vote for each share he or she holds. Yeah. I would also like to introduce the Audit Committee members. Chief Odesoya is present here, Chairman of the Audit Committee. Alhaji Jinodu, also here with us. And Mr. Peter Yanoku, I've seen him also all together there this morning. Thank you. Distinguished ladies and gentlemen, the meeting has been convened pursuant to the order of the Federal High Court granted on Wednesday, the 26th day of September 2024, to enable the shareholders of FanMilk to consider the proposed scheme of arrangement. I would like to call on the legal advisors, Banwa and Ighodalo, to read the court order directing that this meeting be held. It's 6 pages long, but I'll leave it to Banwa and Ighodalo to ask whether or not you want to hear every word or they can abridge it. Please. We are being told that there are copies available and they can be distributed before we commence with the reading. Thank you very much for the observation. Has everyone received a copy now? Thank you. So we can go ahead.
Good morning, shareholders. Please, do I have your permission to read an abridged version of the court order? Okay. Thank you. Federal High Court holding at Lagos, Nigeria, Thursday, the 26th day, 2024, before the Honorable Justice Y. Bogoro, suit number FHC/L 1727/2024, in the matter of an application under Section 715 of the Companies and Allied Matters Act, No. 3 of 2020, as amended. FanMilk Plc, RC 2761 as the applicant. And upon reading the affidavit in support of the originating summons ex parte, sworn to by Olakunle Olusoya, male, Nigerian citizen and company secretary of FanMilk Plc, of Plot 1C, Eleyele Industrial Layout, Eleyele Ibadan, Oyo State, Nigeria, and filed at the Federal High Court Registry, Ikoyi, Lagos. And after hearing Olawale Adeliyi, counsel for the applicants, move in terms of the application. Having considered the ex parte application, the extant laws under which the application is brought, the affidavits in support, the exhibits filed, and the written address, I hereby grant the application as sprayed. It is hereby ordered as follows: that an order is granted directing the applicant to convene a meeting of his shareholders, the applicant's meeting, for the purpose of considering and, if thought fit, approving with or without modification the scheme of arrangement, the scheme in the form and context of the scheme documents annexed hereto. 2. That an order is granted directing that the applicant's meeting be convened and held at the Executive Lounge, Radisson Hotel, Ikeja, 42/44 Isaac John Street, Ikeja, GRA, Lagos State, or such other venue as the directors of the applicant may determine, on the 28th day of October 2024 at 12 noon, or such other date and or time as the Board of Directors of the applicant may determine. 3. That an order is granted directing that the applicant's meeting be held and conducted in any manner as the applicant's Board of Directors may deem fit, including through proxies appointed by the shareholders or from a list of proxies designated by the applicant's Board of Directors, or participation by telephone or other electronic means or such other virtual or audio/visual communication facilities, having due regard to prevailing circumstances, with the notice clearly specifying the instructions on how to participate in that meeting. That an order is granted directing Mr. Olayinka Akikugbe, chairman of the applicant, or failing him, Mr. Kayode Adebiyi, managing director of the applicant, be appointed chairman of the applicant's meeting, or failing them both, any other director of the applicant so appointed in their stead by the shareholders of the applicant present at the applicant's meeting shall act as chairman of the applicant's meeting and to report the proceedings thereat to this court. That an order is granted directing that the shareholders of the applicant can vote at the applicant's meeting in person or through their proxies. That an order is granted directing that if the applicant's meeting approves the scheme by a majority representing not less than 3/4 in value of the shares of members being present and voting, whether in person, physically, by telephone, or other electronic means, or through virtual or audio/visual communication facilities, or by proxy, and thereafter, upon the approval of the Securities and Exchange Commission, a report of the applicant's meeting be presented to this Honorable Court, along with a petition for an order of this Honorable Court to sanction the scheme. That an order is granted directing that, save as otherwise stated, the aforesaid meeting of the applicants be held and conducted in the manner that general meetings of the applicants are held, and in accordance with the provisions of the Articles of Association of the applicants. And the notice convening the meeting may also be sent to shareholders via electronic mail, in accordance with the provisions of CAMA, or the Articles of Association of the applicants. That an order is granted directing that voting at the aforesaid meeting of the applicant shall be by poll. This court order was issued at Lagos under the seal of the Honorable Court and the hand of the presiding judge, the 26th day of September 2024. Thank you.
Thank you very much, Banwa Nigodalo. Distinguished ladies and gentlemen, here is a copy of the scheme document which you received prior to the court-ordered meeting, and copies available should anyone not have come with theirs. Pages 20 to 24 of the scheme document contains the scheme of arrangement referred to in the notice of the meeting. The scheme document to which I'll refer for most of today's meeting contains the following: the explanatory statement to you from the financial advisor to your company specifying the terms, reasons for, and effect of the scheme of arrangement. This can be found on pages 10 to 15. The Fairness Opinion Report on pages 16 to 19. The Scheme of Arrangement itself on pages 20 to 24. Appendix 1 and 2 on pages 25 to 33, which provide further information on the company. And Appendix 3 on page 34, which provides further information on Fan Milk International, FMI, or the core shareholder. The Company Secretary, could you please carry on from here?
Thank you very much, Mr. Chairman. The registrar has confirmed that the scheme document, together with the proxy forms for use at this meeting, were dispatched to all members of the company. With your kind permission, the document will be taken as read. Thank you very much. The notice of this meeting was also published in 2 national daily papers, Punch and Guardian, as you should have seen from the notice convening this meeting. The purpose of this meeting is to consider and, if thought fit, approve with or without modification a proposed scheme document of arrangement pursuant to Section 715 of the Companies and Allied Matters Act, number 3 of 2020 cap, as amended, comma. Thank you.
Thank you, Mr. Olusoye. I wish to say a few words at this juncture on some key aspects of the scheme of arrangement, particularly its envisaged reasons and effects. The reasons for the recommendation. These are the specific reasons why the board resolved to recommend the scheme. 1. The current economic challenges in Nigeria has significantly impacted Fan Milk's business operations over the past year. The recent steep devaluation of the naira and continuing volatility of the exchange rate has escalated the cost of importing raw materials, leading to higher production costs and depressed profit margins. In addition, government policies that resulted in a cash crunch and near hyperinflation compounded the operational challenges that Fan Milk faced last year. In 2023, the company declared a loss of 9.5 billion naira. Despite a 41% increase in prices, revenue declined by 0.31% due to a 29% decrease in sales volume, primarily driven by the currency redesign and resultant cash crunch during the year. Cost of goods sold and operating expenses increased by 5%, despite the lower volumes due to the Central Bank of Nigeria's ban on the importation of milk, which is what we had to go through as a company. A key raw material for production are the subsisting inflationary pressures. The finance interest paid on the company's related party loans also increased significantly from 267 million in 2022 to 11.2 billion in 2023 due to the devaluation of the naira. This eroded profit before tax and returned a negative net income for the year. Losses suffered by the company in the full year 2023 have resulted into a significant negative net asset position of 3.68 billion, and this will continue to worsen if foreign currency obligations are not paid off. To drive future growth, improve earnings, maintain its competitive positioning in the consumer sector, the company needs to restructure its capital by raising new equity from its majority shareholder and/or converting its foreign currency obligations to naira, which may result in a significant dilution of minority shareholders. Given the company's financial performance and its capital requirement, it is unlikely that the company will be able to pay dividends in the short to medium term. These factors have resulted in extensive discussions around the optimal restructuring options for the company, considering its growth plans and funding requirements. The benefits of the scheme. The board believes that the scheme would provide the following benefits to shareholders of the company. It would allow shareholders monetize their shares and receive a return on their investment, given that the company has not paid dividends in recent years and may be unable to pay for the next few years. Shareholders will be able to realize their holdings in the company at a 15% premium to the company's share price of 20 naira on the 31st of July 2024, being the last closing share price prior to the offer. And the transaction will position the core shareholder to support the company more effectively and flexibly in raising additional capital to expand its business operations. So I now go on to the effects of the scheme. The scheme will involve the transfer of the scheme shares comprising 7,383,031 ordinary shares of 50 kobo each held by the scheme shareholders to FMI without any further act or deed. In consideration for the transfer of the scheme shares, the core shareholder will pay the scheme consideration to the scheme shareholders. Following the successful implementation of the scheme shareholders will no longer be shareholders of the company, and the entire issued ordinary share capital of Fan Milk will be held by the core shareholder and its nominee, and the company subsequently will be re-registered as a private company. The company's shares will be withdrawn from the NASD. The consideration. In consideration for the transfer of the scheme shares, scheme shareholders who are on the register of members of Fan Milk as at the effective date shall be entitled to receive 23 naira for each scheme share held as at the effective date. I hope you've all been able to digest all that, and I've been very clear in communicating the benefits of the scheme. Ladies and gentlemen, I will now give you the opportunity to ask questions, comment on all aspects of the scheme. I would request that to assist us in giving appropriate responses, you should refer to the page of the scheme document to which your question is related. Members should kindly ensure that their comments are brief and restrict their questions to one per person so that other members will have an opportunity to ask questions or make comments. I also request that before asking a question or making a comment, you should kindly state your name so we can have the correct names in our records. Let me sit down now for the opportunity for members to ask questions. Questions, please. Sorry for the sisters. If you raise your hand, the person who will hand you the microphone is at the back of the hall. Then they'll be able to see and bring the microphone to you. Please carry on, sir. Name first, please. Thank you.
I want to appreciate the efforts of our board and the management team, for keeping hope alive for Milk Plc. So I'll just go straight to my point concerning the exit price of 23 naira. Mr. Chairman, I'm just a bit worried. This is not the first time that this process started. I think in 2019 we made similar move to actually paid off the minority shareholder. I think that was at 20 naira thereabouts. So I want to know what actually stopped that process. And if you checked in 2019, dollar rate was average was around 360, and today dollar rate is 1,700 or thereabouts. So the price, that 7.38 million, if you are to guess the equivalent of that amount in dollar, from Fan Milk International, that should be about $408,000, will have been paid over the 7.38 million. If we have to use the dollar rate of 360 naira to $1 in 2019. But in 2024, that we did here, dollar rate, just like what I mentioned, around 1.7 or thereabouts. Now, Farm Milk International will paying us $99,000. I mean, is that fair, no, sir? On a normal day, this price should be, should be talking about 80 naira plus, not 23 naira, if we have to be fair to shareholders. So this price that we are paying, it's like it's to our loss. Why the Farm Milk International is to their gain? Because since 2019 to date, we didn't make anything. They are buying us at a loss. Why to them is at a gain? Because if that project went through in 2019, they will have paid $408,000 on these same shares. Now they are coming to pay $99,000. Is that price fair, sir? Because I asked some times ago with the company, it didn't provide me good answer, but I say I'm going to ask here whether that price is fair enough for us. But we didn't receive any dividend, and you are paying us 23 naira. That is not fair, sir. This price must be reviewed. Because you are not the one buying us. It's Flour Milk International, and they are paying dollars, not naira. So that price should be reviewed upward. Thank you, sir.
Thank you. I think, I think maybe we answer the question first before we move on, sir. I think it was not 2019, but 2016 that the last exercise took place. Well, the opportunity was given then, and everybody took the opportunity if they wished at that time. Of course, the circumstances have changed, and I wish that they had changed for the better. In fact, I wish the company had paid dividend every year subsequently. But we can't take away from the fact that the historical situation is what it is, and today we're faced with an entirely different scenario, and an option is being given once again. I think to shed a little light, more light on it, I think maybe you say a word or two.
Our protocol duly observed. Like the chairman has said, when we look at the 2016, the economic parameters, the exchange rate, and even the company performance then is completely different today. Like Mr. Chairman read out in his speech, the company made a loss last year, and what that means is making a loss means that the shareholders' capital have been eroded. What that means is if you have invested, let's say, 10 naira, and the company made a loss, the value will actually come down. Not because the company wanted to make a loss, but because the environment and the exchange and etc. And also to add another point to it, if in 2016, the loan that the company received then was at the exchange of maybe $250 per naira. Today, if the company needs to pay back, the company will pay at about $17.40, which is the current exchange. So you can imagine the impact of the microenvironment on the performance of the organization. I think maybe we can give it to our financial advisor if there's anything they also want to add to that.
This is a conversation. So I thank you for your question. Do you think you have an adequate response for now so that we can move on and allow other people to ask questions, sir? Thank you very much. Mazi, you have a question.
Let me stand on existing protocol.
Can I ask you to state your name for the record, although everyone in the room is familiar with you?
You have already mentioned it, Mazi Samuel Mpamugo. Well, Mr. Chairman, year after year, since that 2016, I think there is none of your AGM which I have not attended. And I always ask, when are people going to pay dividends? It's excuse and excuse, laws and this and that. Even the one held this year, if I'm not mistaken, I asked, you say, going by the trend, that there is a light at the end of the tunnel. Little did I know that this light is what we are here to discuss about the exit of the company. And let me ask, you want to collect the shares from the shareholder, Nigerian shareholders, and now you are telling us how much we are going to sell our share. Is it fair? I never planned to sell my share, just as I did not on 2016. I'm not complaining. Now, I beat my imagination on that aspect. Going by the analysis of my colleague, you think that what you have determined to pay us unwillingly is fair? This is just the question. And again, I don't want to talk too much like before. Now, what will be the position of our Nigeria workers and other stakeholders of this company? So, are we sure that it's not going to be the more you look, the less you see? So let me end up in this way because, I don't know what to say.
Thank you, Mazi. Like I mentioned earlier, it's never a pleasant thing for a board of a company to come to an AGM and they're not being able to give a return to the shareholders of the company. The light at the end of the tunnel always worries me because it could be a train coming in the opposite direction. So it's not an analogy that I feel comfortable with. But however, the truth is that Fan Milk, the core shareholder, has, I think, been very fair to the company in the sense that they've continued to invest in an environment that has been, for the want of a better word, difficult. The company, before they bought into the company, had difficulty paying dividends anyway. And at that time, it was the problems of sufficient capital and a mismatch sometimes in the production facilities vis-a-vis the distribution and so on and so forth. They bought the company and they decided that they were going to make it a world-class company befitting the companies that are in the group of Danone, which is itself a world-class company. They have continued to invest, and I think that has been very good for Fan Milk and for us as Nigerians and for the Nigerian shareholders, the minority shareholders that have remained. They are continuing to do so. So this is not an exit in any way by Danone. The workers in the company continue to support the company. We have excellent relations with the workers in the company. And no one has left the company as a result of the company restructuring its workforce in any way. If anything, they have continued to invest in the workforce. So I think it's very important that I let everyone know that Danone has continued to show interest, continued to show faith, continued to invest in the company to make it stronger. But the environment that it has been working in has been very difficult, and for reasons that we all know. But I don't want to speak alone on this, and I think I would like to invite Dr. Ajibade to say a word or two as my co-director.
Thank you, Chairman. I think you've made all the points that need to be made. The decision that Danone has taken to offer to buy out the minority shareholders, I think has been well thought through. You've already stated the reasons in your comments. I think given the amount of investment that it has made, what is driving this really is the need for more flexibility and the ability to take decisions that will be for the benefit of the company, but without having to go through the rigor of dealing with what is right now a public company. The desire is to take it private so that it can be a lot more flexible, can raise capital in a wider variety of ways. The question as to the pricing, really, we need to be realistic as to what the current state of the Nigerian economy is and factor that into the decision. Referring to the point that was made in the earlier question about the pricing in 2016. Nigeria in 2016 is not Nigeria today. So we can't really, we're not comparing apples with apples if we're looking at what happened in 2016. I think it's unfortunate. Shareholders who did not take the opportunity to exit in 2016 clearly are at a disadvantage. There's no doubt about that. But we can't draw parallels between the numbers in 2016 and the numbers now. So I urge shareholders to take the opportunity now that is being presented again. Thank you.
Thank you, Dr. Ajibade. And if I might just add one more thing, which is that a fairness opinion was sought and received on the offer price. And it is an offer. That's why we're here today, because it's an offer that the shareholders have an opportunity to take. And we are advising that this is an opportunity to do so, but it's still a conversation. So can I ask if there are any further questions? From the back, name please.
Thank you, Mr. Chairman. The name is Adelakun Lukman Adeshola. I've listened attentively to your points and the explanation as regards the issue of the offer. But I want to ask this question, that since we know that FAMIC is having challenge vis-a-vis the economic situation in the country, that is why you are offering us that you want to buy off the minority shareholder. Not that you are you are leaving Nigeria. To me, my understanding is that if the business is not profitable anymore, they will have said, fine, we are leaving this country, because they cannot, like maybe, for example now, GSK, as we are all aware. But for the fact that you are not leaving Nigeria, you just want to buy off the minority shareholder and still be collecting our money. You still want me to be buying the same product for my children, the same product for my family, and you don't want me to be a part of that same business. Is that fair enough for the Nigeria shareholder vis-a-vis the years you have not been paying dividend? Please, I want explanation on that. Thank you.
Thank you very much for the question. Once again, I will remind all of us that as a shareholder, if you haven't received dividends in the past, it's also because the majority shareholder has continued to invest in the company. and they've been investing in foreign exchange. They have showed that they are willing to give this investment that they have made an opportunity to grow. In order to grow it, they have to continue to invest, and inevitably in foreign exchange, because the production equipment that the company uses inevitably has to be imported. The majority of the Nigerian component is in the labor that you require for sales and distribution and so on and so forth. Now, if they continue to invest, minority shareholders will continue to be diluted, and the value of their shares and the proportion will continue to go down. At the moment, minority shareholders constitute about 0.7% or 1% of the company. This is why those on the board have had to engage the majority shareholder to make sure that we protect the interest of the minority shareholder and give the minority shareholders an opportunity to exit the company at this stage, knowing that the future, the short to medium term future of the company, they will not be able to realize any dividends for their investment, and they will also more than likely be diluted. So that is the reason. Danone is not exiting Nigeria now. They've made that clear to us. I don't know what the future holds. But the level of investment they continue to make, and I remind you that we are part of a group of companies. They have a company in Ghana, Togo, Ivory Coast. So their efforts are spread over West Africa. However, they continue to show faith in Nigeria. So this, I think, is my explanation of why we're here today, to give an opportunity for all the minority shareholders to look for other investments that might be better suited for their funds. The issue is price, as you have made clear, right? And although we've had an offer made and we have scrutinized that offer on the board, the process has required us to get a fairness opinion, and that is independent. They look at all the numbers and say, well, this is what is a fair price for the company given, the finances as it were. And the price they arrived at was 23 naira. Now, I think at this point, we need to take some time, a recess for about 15 minutes. Yeah, please.
Thank you, Chairman. Thank you for the opportunity. There's just an additional point that occurred to me that I think it's important to make, especially for the benefit of Mr. Adelakun. There's a public company. Running a public company comes with certain obligations. And if you're a listed company and you have a significant percentage of your holding that is held by members of the public, it makes sense to incur those costs. It makes sense to carry that responsibility. But for a company that is 99.7% owned by a single shareholder, it really doesn't make sense to continue to incur those costs, the public reporting costs, the expenses of being listed on the NASD, of having to report to SEC. So these are all the factors that have driven the decision. It's not just a desire to exclude Nigerians. And it may very well be that 5-10 years down the line, the company will decide to have a public offer and bring Nigerians in large, maybe a 20%, 25% offering. But for now, it just doesn't make sense to continue to incur those responsibilities just to cater for a 0.3% shareholding.
Thank you, sir. If that be the case, sir, we can give you 1 hour to go and review the offer, sir. We are here for you, sir.
Thank you very much. I hear you. We will take a short recess so that the shareholders in the room can also discuss the fairness of the price that has been offered. We on the board will also consult the core shareholder and tell him that this is what the meeting has said. Can we get an improvement on the offer to present to them? So we'll take about 15 minutes. Please do not go outside. As you can hear, it's raining heavily. There's plenty of room, both in here and outside in the corridor to discuss. So we'll adjourn the meeting briefly for about 15 minutes. Yeah. Yes, of course. Can we please pay attention so that the members...
Thank you, Mr. Chairman. I think you saw 2 or 3 shares are going now. So we're going to deliberate on it before you go to your research. You can also think about our own price. We are suggesting, because we've done our plus or minus, that 15 naira should be given to us, sir. Thank you, sir.
Thank you very much. At least it's good to have something to be able to discuss with the core shareholder. So 50 naira is your suggestion. After discussing with others, we'll take that to them. So 15 minutes, please. It's now 1:45, so 1 p.m. we'll reconvene. Thank you very much. Distinguished ladies and gentlemen, can I ask you to take your seats so we can continue with the meeting? Once we're all seated, we'll be able to continue. Distinguished ladies and gentlemen, we called the recess to give us an opportunity to tell the core shareholder what the mood was in the meeting. May I just remind everyone that as chairman of the company and having the other director here, our major responsibility is actually for the minority shareholders. So we are very much interested that we resolve this matter in the best way possible for the minority shareholders. But I'm also reminded in the conversation that I just had with the core shareholder that they too have responsibilities to their shareholders, and their shareholders, their regulations demand certain things of them. And they feel that they have exercised their responsibility, their official responsibility, by looking at the finances of the company, their plans for the future, and also the fairness opinion that has been given to them. We have prevailed on them to understand that the history of the company demands that we be kind, to put it that way, to the people who have shared in the investment all these years, even if they're going to exit. The comeback from them is that we can increase the offer so that we can get a resolution, but they do not wish for us to go back and forth on it. They reminded us that the negative asset situation of the company meant that even the 23 naira they were offering was generous in terms of the financials of the company. So their comeback to us is for us to make an offer to the minority shareholders of 30 naira. 30 naira represents an additional, I think, 50% on their initial offer. I don't want to couch it as a take it or leave it offer, because that is not the attitude which they have. They're simply saying that when they reference their own authorities, this is what they are allowed to do, and that is the offer that they can make. And if the meeting accepts it, they will be happy to keep to that offer of 30 naira. So having received that offer, and knowing that we are not going to be able to go back to them, the next process would be for us to take a vote on the offer. Company Secretary, would you? Yeah. Okay. I think it's also fair, since we in the room are the minority shareholders, that I take a few comments on this offer, which of course we will relay regardless of its effect. So if there's anyone in the room that has any further comment to make, can I ask that they make it now, by raising their hand? Mr. Aloha, I think the phone.
Chairman, shareholders, our protocol observed. I wish that if you can be raised to 35, it could be manageable. Could be manageable due to the economic shock. Thank you.
Any further comment? Mazi.
Mr. Chairman, I'm a Christian. And I read a portion of the Bible that says man had donated his fellow man into his injury. That's exactly what we are seeing. The one that has the power to rule can just take a decision and implement it, even without we knowing. So since that is the case, and knowing fully well that you people are also part of us, and you have agreed that it is fair, what can we do? The court is there for you to pay whatever you want and get the judgment. And we just go empty-handed. So, for that reason, we cannot do otherwise. We have agreed, negotiated very well. And our concern is that the relationship, we want it to continue with other members of Nigeria.
Thank you, Mazi. Let me state quite clearly that this was not take it or leave it. And our responsibility was to ensure that this matter was dealt with according to the law and with the best interests of the minority shareholders at heart. And Danone itself, in any case, which is, if you wish to remain in the country and continue with your investment, you want to do so with the support not just of the historical members of your company and its shareholding, but also to the public at large. And that means that they're looking to be fair and straightforward in their dealings. Their offer is 30 naira, Mr. Loha. That's the mandate that I have been given to report back to the meeting. And unfortunately, that is where they are stopping and saying that we should take a vote. And that is why I made it quite clear that from their perspective, the negative asset holding of the company makes it very difficult for them to explain to their own owners why they're making an offer that's far in excess of what ordinarily they will be getting in the situation. We know the situation of the economy of the country and what has led to this, and it's unfortunate, but it is what it is. If in future the economy improves and there's another opportunity to return back to the Nigerian stock market, I'm sure, but from what we know of the way they have dealt with the company, we'd all once again look forward to being shareholders, assuming, of course, that this morning we accept the offer. I personally would urge minority shareholders to take this offer because I think it's fair, and I've worked along with the directors very hard to ensure that we didn't just take what was the price on the NASD over the years, the historical price of 20 naira. So they've moved to 30 naira, and now I'm going to go forward with the vote, as it were. So, ladies and gentlemen, final comment, please. Thank you.
Thank you, Mr. Chairman. I think I want to appreciate the effort of the board. I mean, in not sticking to that, we went for that to go and negotiate with the Farming International. I think that is good enough. Thank you very much. Then I also want to ask this question concerning our representative on the audit committee member. I don't know what is their fate, but I think that question was not answered. What is their fate? Are they also going to be paid out, or is the company retaining them? Thank you very much, sir.
Well, there's probably two aspects to that. The first aspect is as shareholders, they're not treated any differently from any other shareholder. But as to the nitty-gritty of the audit committee and the board, I think that is something the board itself would consider with the core shareholder, because, of course, the companies would still need an audit committee as a private company, I assume, but that is not something that I can answer here and now. But otherwise, they are treated just like any other shareholder. Mr. Olusan, did you have a comment?
Absolutely, Chairman, you're correct. Because they cease to be shareholders, because they're representative of the, if this offer goes through, they cease to be shareholders. But what we're also trying to do is basically have a stable condition, depending on what the board tells us, we'll come back to them. But like Chairman has said, we want fairness in this transaction, make sure everybody is happy, and then we can get what we want from this transaction. Thank you very much.
Thank you. Ladies and gentlemen, let me go through the formal process of letting you know that we have consulted with the core shareholder, and it was proposed that the scheme consideration be increased to 30 naira for each scheme as at the effective date, and that represents, if my maths is right, 50% increase from the initial offer of 23. If this is satisfactory, the legal advisor will proceed to amend the scheme consideration in the sub-resolutions. The resolution to increase the scheme consideration will now be tabled for your approval, and if thought fit, passed as a special resolution with the rest of the subjoined resolution. The resolution to be considered, and if thought fit, passed as a special resolution with the rest of the subjoined resolutions, and in replacement of the scheme consideration contained in the second sub-resolution is as follows. That the amount of the cash consideration for the transfer of the scheme shares, which is to be paid to the holders of the scheme shares of Fan Milk, be increased from 23 naira to 30 naira, and that all references in the scheme document and ancillary documents in respect of the scheme to the cash consideration be paid to the holders of the scheme shares be deemed to have been changed from 23 naira to 30 naira. I hereby request that someone move a motion for the resolution just read by the company secretary read by me, as a matter of fact, be approved, and that be passed as a special resolution with the rest of the subjoined resolutions and in replacement of the scheme consideration contained in the second sub-resolution. Would someone please rise and move the motion?
Thank you, Mr. Chairman. Having duly considered us, which we finally accepted, I so do. The name is Adelakun Lukman Adeshola. Thank you very much, Mr. Chairman.
Thank you very much, Mr. Adil Lukman. Would someone please rise and second the motion?
Thank you, Mr. Chairman. My name is Engineer Binyo Shakapateju. I second the motion.
Thank you very much. Could you please repeat the name? I don't want to get it wrong.
Binuyo Sharafateju.
Binuyo Sharafateju. Thank you very much, sir. Ladies and gentlemen, the amended subjoined resolutions to be tabled for your approval will now be read by our company secretary, Mr. Olusanya.
Thank you very much, Mr. Chairman. The amended subjoined resolution to be considered and, if thought fit, passed as a special resolution are contained in the notice of the meeting on pages 35 to 37 of the scheme document. I will now read the subjoined resolution for consideration. That the scheme as contained in the scheme document dated 26 September 2024 with or subject to modification, addition or condition agreed at the meeting and or approved or imposed by the Securities and Exchange Commission SEC and or the court, a print of which has been submitted at the meeting for the purposes of identification endorsed by the chairman be and is hereby approved. 2. Subject to the sanction of the court and delivery of the sanction for registration at the Companies Affairs, Corporate Affairs Commission, A consideration for the transfer of the scheme shares as defined in the scheme document. Each scheme shareholder as defined in the scheme document shall receive 30 naira per share, scheme share held by such scheme shareholder. B. As a result of the scheme, the legal and beneficial ownership of the scheme shares be transferred to Fan Milk International AS. C. That the company be registered as a private limited liability company. D. That the name of the company and the memorandum and articles of association of the company be amended to reflect its status as a private limited liability company. E. That the shares of the company be withdrawn from NSD OTC Securities Exchange. Number 3, that the board of directors of the company be and are hereby authorized to consent to modification of the scheme of arrangement that SEC and or the court may deem fit to impose and approve. 4, the board of directors of the company be and are hereby authorized to take all actions deemed necessary to give effect to the aforementioned resolutions of the company or as may become necessary to put the scheme arrangement into effect. And 5, that the solicitors of the company be directed to seek orders of the court sanctioning the scheme and foregoing resolutions, as well as such incidental, consequential, and supplemental orders as are necessary or required to give full effect to the scheme. Thank you.
Distinguished ladies and gentlemen, I hereby move the motion that the amended subjoined resolution just read by the company secretary be approved. Would someone please rise and second the motion?
Thank you, Mr. Chairman. I second the motion. Igbasami Bukola is my name.
Igbasami Bukola, thank you very much for seconding the motion. Ladies and gentlemen, voting on the resolution will be by poll, which means that every shareholder present in person or by proxy shall be entitled to 1 vote for every share that he or she holds. The statutory majority required to approve the scheme is a majority representing not less than 3/4 in value of the shares of members present and voting either in person or by proxy at this meeting. I confirm that a number of shareholders who are unable to attend this meeting have sent in their proxy forms indicating how their votes will be cast. Fan Milk International, the core shareholder, will not exercise their right of voting at this meeting in compliance with the guidelines of SEC on the scheme of arrangements. In order to facilitate the voting process, the voting pads which have been circulated or will be circulated to members this afternoon will be used. And this is a process we have used at our AGMs and quite familiar to those who have attended those meetings. The voting pads in your hand should carry each member's number of shares verified by the registrar upon arrival at the meeting. When voting for or against the amended subjoined resolutions being considered, you should cast your vote by clicking the appropriate button on the voting pad. I will now call on the registrar to explain how to use the pads before voting commences. Thank you.
Thank you, Mr. Chairman.
Voting devices have been issued to shareholders eligible to vote. Each device has been activated and is ready for use. A resolution will be announced, and voting for the resolution will Electronic voting devices have been issued to shareholders eligible to vote. Each device has been activated and is ready for use. A resolution will be announced, and voting for the resolution will commence after the announcement. On the voting pad, 1 represents yes, 2 represents no, and 3 represents abstain. Press 1 for yes, press 2 for no, press 3 for abstain. Voting for a resolution commences and ends in 30 seconds. Voting results will be displayed immediately each voting session ends. Results will be displayed in shareholding percentage and unit holding. Electronic voting devices make voting convenient, fast, and secure. Thank you for participating in this important decision-making process.
Thank you. We will be capturing the votes of shareholders physically present at this meeting, in addition to the pre-received voting patterns of shareholders by proxy to get the final voting results. We note that the core shareholder, who owns 99.37% of the issued capital, is not eligible to vote. When you came in this morning, you were given a voting device that we have configured to represent your shareholding in Fan Milk. Esteemed shareholders, for coherence, note that the voting results displayed will round up the percentage of the shareholding to a whole number. Thank you.
Thank you. I trust that that's very clear. We've used these devices before, and I don't know about BVAS, but these ones are very accurate. I will now put the meeting and ask all the shareholders to vote either 1 in favor. Yeah. I just have to read this portion out before these. 1 in favor, or 2 against, or 3.
Thank you, Mr. Chairman. The subjoined resolution is up on display, and the timer starts now. Please vote. The timer starts now. Please vote.
Can we vote?
Yes, we can. 1 for yes.
Can we vote?
Please vote. 1 for yes, 2 for no, and 3 to abstain. Voting has ended, and we have 99.8% in favor of the resolution, which translates to 99.87% in favor of the resolution. And this translates to 3,891,000 units of the shareholdings. Thank you, Mr. Chairman. No. Oh, we have 5 against the resolution, 5,000 against the resolution, 3,891,000 for the resolution, and 5,000 against the resolution. No abstain.
Thank you very much, Mrs. Greenwich. Just waiting for the official results to be given to me by the scrutineer before I announce the result. Distinguished ladies and gentlemen, based on the results of the poll, the result is as follows. The units of shares for are 3,891,000, and as a percentage, it's 99.87% of those voting. The units of shares against are 5,000, and in percentage terms, that's 0.13%. No units of shares abstained, and this has been signed by Greenwich Registrars and Data Solutions Limited, Okweyemi Ojomo, on 28th of October 2024, and the scrutineers were Forbes Mazars, who have also signed this document, Obianuju Rechuku, having signed it for them, dated, of course, today as well. Based on the results of the poll as read out to you, I declare the resolution approving the scheme of arrangement carried. The report of the result of this meeting will be filed with the Securities and Exchange Commission for its final approval. Following the grant of the final approval by SEC, a copy of the results will also be submitted to the Federal High Court to enable it sanction the scheme of arrangement and delivered at the Corporate Affairs Commission so that it may become effective. Ladies and gentlemen, the announcement of the results has brought to a conclusion the business of the court-ordered meeting. I would like to especially thank everyone who has come along today to participate, and I thank you for giving us, your directors, your support, and for trusting us to have acted in the best interests of the minority shareholder. This has been a long journey from over 60 years ago, and I and Mr. Ajibade, Mr. Lohan here, whose father was a member of the company, my mother there, Mrs. Agibu Kema, and a number of other shareholders have kept faith with this company for over 60 years. We should be proud of ourselves that a company that started so long ago is still fully functional, still working, is still employing Nigerians, and it still has a bright future guaranteed by its now 100% owner, Messrs. Danone. I'm very proud of having been part of that journey, and I think so are happy to have been on the journey too. The one thing is that those of my generation that were drinking fan milk in school 60 years and more ago will continue to be able to do so in the future. I thank you all on behalf of the Board of Directors of Fan Milk for taking the time to attend this meeting today, and I have no other obligation other than to declare this meeting closed. Could we please rise once again for the national anthem?
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians all and proud to serve our sovereign fatherland. Our flag shall be a symbol that truth and justice reign in peace or